I am TJ, joined by Diana. This is Bureau of Prisons Watchers for Saturday, June 20th, 2026.
Good to be here. And we have a lot to get into today. Some of this news is genuinely alarming for people inside right now.
It really is. We are starting with a court ruling that could affect thousands of people serving federal time across the country.
Okay, set it up.
The Fourth Circuit Court of Appeals has ruled that if you have even one disqualifying offense on your record, you get 0 First Step Act earned time credits.
0, not reduced, not partial, 0.
0. And to be clear, this is not just about credits tied to that one conviction. It wipes out all of your credits across the board.
So someone could have done years of programming, earned hundreds of days in credits, and one old conviction just erases all of it?
That is exactly what the court said. The ruling was published in Prison Legal News in April 2026, and it came out of a November 2025 decision.
And this covers the Fourth Circuit, which means Virginia, Maryland, North Carolina, South Carolina, West Virginia. That is a massive population.
Right. And the concern is that other circuits could follow this reasoning. This is not just a Southeast problem. It could go national.
What are the disqualifying offenses we are talking about? Because I think a lot of families do not realize their person might have one.
The First Step Act lists them. We are talking about certain violent offenses, terrorism-related convictions, sex offenses, some drug offenses with enhanced penalties. It is a long list.
And the court is saying the Bureau of Prisons cannot separate out parts of a combined sentence to apply credits to the eligible parts.
Correct. The court refused to disaggregate the sentence. If any piece of your conviction is disqualifying, the whole sentence is treated as disqualifying.
That is a tough interpretation, and families are just supposed to accept that?
Well, the litigation is not over. People can still challenge this. But right now, in the Fourth Circuit, this is the law.
So what does someone do if they think this affects them?
First, find out what your pattern score is. Understand your offense of conviction, and talk to your attorney about whether you have a disqualifying offense under the statute.
And do not just take the case manager word for it. Get eyes on your actual paperwork.
Absolutely. This is one where you need to verify, not assume. The Bureau of Prisons has been inconsistent in how it applies these rules.
Which is part of why there is so much litigation clogging the courts right now. People inside are getting different answers depending on which facility they are at.
And that inconsistency is a real problem. If you need help understanding your FSA credit eligibility, visit FSA4U.com. We will talk more about that at the end of the show.
Okay, story 2. This one is actually a little more hopeful, at least on the surface.
Yes, Bureau of Prisons Director William K. Marshall III signed a new policy statement on May 7th, 2026, changing how the agency handles lockdowns.
And this is a significant shift from what families have been dealing with for years.
It is. The old default was facility-wide lockdowns. One incident anywhere in the prison and everyone loses access to programming, phones, visitation, everything.
Which families know all too well. You are planning a visit and you get the call that the whole facility is on lockdown because of something that happened in one unit.
Right. The new policy says lockdowns should be limited to the specific housing unit involved in an incident, not the whole facility.
That is a meaningful change. So if there is a fight in Unit C, Units A and B should still be able to operate.
That is the idea. And the policy also sets minimum daily conditions that must be maintained even when a unit is under modified operations.
What does that mean in practice? Like, what are people guaranteed even during a unit restriction?
That is where details matter, and we are still waiting on the full implementation guidance. The summary came from Federal Prison Tips on Instagram, citing the policy directly.
So the policy exists. Whether it is being followed consistently is a different question.
Always. With the Bureau of Prisons, the gap between written policy and actual practice can be enormous.
If your person is still seeing facility-wide lockdowns after May 7th, 2026, that is worth documenting and raising with their attorney or a prison rights organization.
Good point. Write it down, date it, report it. Policies mean nothing if there is no accountability. Before we continue, a quick word from our sponsor. If you or someone you love is dealing with a life insurance or annuity question, Policy Prepper is the resource you need. Plain English, no sales pressure, just real information at policyprepper.com.
Seriously, check it out, policyprepper.com. Now back to the news.
All right, story 3, and this one connects directly to story 4, so we are going to take them together.
Halfway houses. This has been building for a while.
Yes. Two recent Bureau of Prisons directives are raising serious concerns that fewer people are being sent to residential reentry centers before release.
And for people who do not know, a residential reentry center, an RRC, is what most people call a halfway house. It is supposed to be the bridge between prison and home.
Under federal law 18 U.S.C. 3624C1, the Bureau of Prisons is authorized to place someone in a halfway house for up to 12 months before their release date.
Up to 12 months. That is the law. And that time exists specifically to help people get a job, reconnect with family, and get stable before full release.
Now here is story 4, which makes this worse. In June 2025, the Bureau of Prisons issued a memo capping halfway house placement at 60 days for most people.
Wait, 60 days. Down from what had been 6 months to 12 months standard.
Correct. What used to be a 6-month runway is now for most people 2 months.
That is not a bridge. That is a curb. You cannot rebuild a life in 60 days.
And advocates are pointing out that this likely means more of that transition time is being spent inside prison walls instead of in the community.
Which defeats the entire purpose of the reentry process. The whole point is to get people back into society gradually and with support.
The legal tension here is real. The statute says up to 12 months. A memo cannot just override a statute.
So is this being challenged legally?
It is being watched very closely. Advocates and attorneys are looking at whether this memo violates the statute. We do not have a court ruling yet, but this is live litigation territory.
And in the meantime, real people are getting 60 days instead of 6 months. That affects employment, housing, everything.
If your person has a release date coming up and you are trying to plan around halfway house time, do not assume anything. Ask the case manager in writing what the RRC recommendation is.
And get it documented. If they are told 60 days when the law allows 12 months, that is something an attorney needs to know about.
Exactly. Do not just accept a short placement without asking why and getting an answer in writing.
Okay, before we close, know your rights. Because we always want to leave people with something they can actually use.
Today, it is RDAP, the Residential Drug Abuse Program. If you qualify and you complete it, federal law 18 U.S.C. 3621 E2B allows a sentence reduction of up to 12 months.
12 months. That is the single biggest sentence reduction tool available inside federal prison, outside of a court motion.
And it comes from the director of the Bureau of Prisons directly. It is not discretionary in the same political sense. It is a legal authority tied to program completion.
Who qualifies? Because people are always confused about this.
You need to have a documented substance use disorder and be serving a sentence for a nonviolent offense. There are exclusions, including some weapons and drug trafficking enhancements.
So if you think you might qualify, the time to apply is not 6 months before release. It is now. The wait lists are long.
Very long. Some facilities have RDAP wait lists of a year or more. If you wait until you are close to your release date, you may miss the window entirely.
Apply early. Document your substance use history. Get a diagnosis on record if you do not have one already.
And if you were denied, ask for the reason in writing and talk to your attorney. Denials can sometimes be challenged.
This is one where the paperwork really matters. The Bureau of Prisons runs on documentation, and so should you.
All right, let us bring it home. A lot of heavy news today, but knowledge is what protects people in this system.
And people on the outside, families, attorneys, advocates, you are part of this too. Stay informed, stay loud.
If you need help calculating FSA credits, release dates, or RDAP timelines, visit FSA4U.com, the only calculator that actually gets it right. And if this show has been helpful, please subscribe and leave us a review. It helps families just like yours find us.
To everyone listening, whether you are inside, at home, waiting, or fighting for someone you love, you are not alone in this. We will be back Monday. Take care of each other.